from a TradFi perspective, like, the core metrics you can look at are like ETF flows. Bitcoin's got 54 billion since launch, and that's up. That's the top. It's basically all-time highs in net flows. You've got people quite excited. The Treasury companies are doing a lot of the work here. There are 50-something Bitcoin Treasury companies that we know of, maybe more. There are still people who are saying, because the government has changed its mind, I kind of like it now.
Welcome, everybody, to a very special edition of the Bitcoin Policy Hour. This is the out-of-office edition. Zach Cohen and Matt Pines are traveling and going to some conferences as they do. So I'm Stephen Pollock. I'm the SVP of Development at BPI, joined today by Zach Shapiro. And Alex Thorn with Galaxy has decided to drop by for the Bitcoin Policy Hour podcast. So thank you guys for joining. We've got a lot to go over today. A number of things are happening. We had a couple of executive orders come through this week. We're going to talk a little bit about TradFi Bitcoin adoption, and it's a new day at the SEC, according to the SEC. And so we're going to hit on that a little bit, Project Crypto. But first, we don't want to bury the lead here. Zach, I know something near and dear to your heart, especially in all of us. We have a verdict in the Roman Storm case. Fill us in on everything we need to know about that, and let's camp out there for a little while here at the very top.
Yeah, we did in fact get a verdict in Roman Storm's case about the Tornado Cash privacy tool. This had gone to trial after Judge Fela, who's the judge in the Southern District of New York, had denied the motion to dismiss in this case on the legal issue about whether or not non-custodial tools could constitute money transmission under the Bank Secrecy Act and Section 1960. And this was always going to be a little bit of an uphill battle in front of a jury. In the American legal system, juries decide questions of fact and judges decide questions of law. And so this was an opportunity for the jury to look at each of the three crimes that Roman was charged with and decide if, based on the facts that the government presents as evidence, that beyond a reasonable doubt he was guilty. So there were three charges in this case. There was a conspiracy to commit money laundering, there was a sanctions evasion charge, and then there was a unlicensed money transmission charge. The jury was unable to reach a unanimous verdict as to the money laundering charge or the sanctions evasion charge, and so the government could retry each of those crimes in a future trial, but probably not super likely to do so. And they got a unanimous conviction on the unlicensed money transmission charge. Now, despite the fact that the unlicensed money transmission charge has the word unlicensed in it, the specific conduct that the government is alleging here has nothing to do with having a license. There is a subpart or an object of the conspiracy that Storm was charged with that requires transmitting funds that Storm knew were the proceeds or derived from the proceeds of criminal activities. So this is something you could be charged with even if you actually had a valid license. And so the jury necessarily found that Tornado Cash transmitted funds and that Storm knew that those funds derived from crime. And again, knowledge here is different than intent, which Storm was charged with in the money laundering charge. So it's not that Storm intended to help criminals. It's just that he knew criminals were using the tool. So the part of this that's a real awful from a precedential perspective is the idea that a non-custodial tool like Tornado Cash, as opposed to the users of that tool, transmitted funds to begin with. Based on the 2019 FinCEN guidance, which maybe we should come back to and talk about a little bit, and based on the sort of just plain English meaning of accepting and then transmitting funds, you would think that it is the users of Tornado Cash who use their private keys to deposit ETH and withdraw ETH using a zero-knowledge proof were the ones who were transmitting money privately, and that it was not Storm who did not have access to those funds, did not have the ability to upgrade or change the smart contract or move those funds. He was not the one who was transmitting the funds in question.
So real quick, Zach, how does that happen then, right? Like, we know that seems obvious. Is it just, this is what happens when you go to a trial? Like, is it, what do you think? What wires got crossed?
So before it went to trial, there was the legal argument on the motion to dismiss as to whether, as a matter of law, the judge in this case should have dismissed that charge by saying, listen, if you look at the Bank Secrecy Act, which treats you as a money transmitter if you accept and then transmit funds, that somewhere between accepting and then transmitting funds, you need to have those funds. You need to custody or control those funds. As a legal matter, the government couldn't prove that he transmitted funds just because everyone agrees that this tool is non-custodial, and the government didn't plead that the tool was anything other than non-custodial. So I think it was last October, Judge Fela ruled that the Bank Secrecy Act does not require custody or control. This was a very controversial ruling. I'm on the record as to saying I think that's totally wrong. But once that was decided as a matter of law, it was hard to expect a jury of Roman's peers who are not experts on cryptography or crypto or any of these sort of finer nuances of how the Bank Secrecy Act works to get this distinction. So I think the appeal that Storm is going to do now is probably going to be on Judge Fela's motion to dismiss decision more than it will be that on the jury's verdict, because I think at the end of the day, this really was more of a legal question, a factual question. I think with respect to this charge, it was probably pretty doomed by the time it went to trial in the first place.
Right. Alex, I know you're kind of had the ear to the ground on this too. What are your observations and kind of concerns moving forward here?
Yeah, I think it is concerning. I totally agree with Zach's concern about the unhosted wallet or the non-custodial service, or however you want to describe that Tornado Cash was. If you just sort of think about, the fact that the legal question, the fact questions were narrowed down so much to did criminals use it and did he know? That's why it's, I guess they're like, yeah, I mean, I guess he did know. There's evidence that he was aware. He surely couldn't have stopped it. So just like as a fundamental nature, and I appreciate Zach too clarifying the actual like meaning of that charge, because when you say like conspiracy to operate an unlicensed money transmission business, I think most of us think like that would be a business, right? Like that is like, and when you hear the word conspiracy, you think it means like, we're getting in together in a room together and we're hatching plans and we're planning and plotting. And the reality is like, that just isn't what Tornado Cash was. Like, that's not at all what it was. It just doesn't make any sense. So I hope that, Roman has grounds to appeal. Every lawyer I've talked to, I know Zach is expecting appeals like that. Apparently there are a lot. I wasn't able to follow like the pretrial motions and stuff in this case, but it's a bad precedent for sure. It was a bad day for the internet and internet privacy, I would say, broadly speaking. And the other thing that really sticks out to me, and maybe this is a good segue into the FinCEN stuff, because FinCEN is an agency inside the Treasury Department that is tasked with overseeing and administering the federal registrations of money service businesses, right? And one thing that really sticks out to me about this, and not just the ruling, the case was started before the current administration was in office or the current DOJ was in power, and litigation and criminal and civil cases can go. It's weird. I mean, cases are complicated, right? So they can go different ways, sort of regardless of what policy ideas the people in power have. But Jay Clayton praised his team for stopping criminality. And if you read the presidential working group report, that came out, at this point a couple weeks ago, it's not particularly supportive of crypto's views on things like the Bank Secrecy Act. It's better, I think, than this DOJ SDNY trial team's view of this. But I think people don't necessarily realize that like Bitcoin and the crypto industry is getting all these wins on these things, but the financial surveillance apparatus that really escalated after 9/11 is quite intractable. And there are other it's not just crypto that cares about it, right? There's huge national security things, and rolling that back and sort of getting like, you look at all the stuff that this administration has done that's positive for the crypto and Bitcoin industries, and then you look at this Roman Storm case, and it's kind of hard to square that circle. But the reality is like BSA, financial crime, illicit activity related stuff, AML, KYC, all of that stuff, they're not really rolling it back, not quite. So like that, people should remember that, like, and by the way, most of that stuff is like pretty much the most important and existential policy issues. Which regulator regulates which type of token, it matters, but it's not like existential. And if software developers can be held liable for the use of their non-custodial tools, then we got huge problems across the whole stack here. So I think that's the thing that really stands out to me, is the tension between the industry and FinCEN and Treasury and DOJ on this topic.
Yeah, I think that is a real tension. And I think some of this might be, it seems on the surface like there is sort of less money at stake on these questions of where exactly is the line of being a money transmitter versus not, whereas there's a lot of money immediately at stake about what's a security versus what's a commodity. But I think, Alex, as you rightly point out, if you really interrogate the concept here, it's pretty obviously existential, right? So what was Storm convicted of? He entered into a conspiracy, right, which is an agreement between at least two people. And they took some step in furtherance of that conspiracy to operate a money transmission business that they knew would be used by criminals. So with most businesses, you're agreeing with at least one other person to do the business. So the conspiracy thing is pretty broad. The knowledge thing, also pretty broad, right? Makers of all sorts of tools know that criminals are going to use them. Apple knows that people are going to use MacBooks to commit crime. The companies that manufacture USB cables know that some people might use those to commit wire fraud. If you're part of a lumber company that chops down trees, maybe you think that some of that wood will go into paper that ends up in an envelope that one criminal will use to hand another criminal cash, right? So the knowledge part is really broad too. So then the question is, the only thing that's left is, what does it mean to transmit funds? And if it doesn't require that you custody or control funds in order to transmit them, besides the bastardization of the English language, if merely it takes, you need to create some tool that facilitates other people transmitting funds, then you do reach the lumber company, right? Certainly you reach people who create non-custodial wallets, which is a software that helps you create private keys. You reach people who run nodes, right? If I use my Ledger wallet and I broadcast a transaction, I use Ledger Live software to send that transaction to the mempool. They are facilitating my movement of funds. Miners append transactions to the blockchain. Stakers, certainly any kind of DeFi protocol, layer twos, you name it. And so if Web3, if crypto, if Bitcoin is going to be worth anything at the end of the day, it's because it is this peer-to-peer trustless network. And if we're going to make it a crime to build any of the tools that allow people to use Bitcoin and crypto in that way, that's pretty short-sighted if we're going to mortgage that to have a safe harbor for ICOs.
And part of the argument that the DOJ made in this case regarding that FinCEN guidance was that the guidance didn't address the idea of control. But like, that is fundamental to the concept of money transmission anyway. It's like, it's almost a given, right? These laws and regulations were created so that when you go to a Western Union to send money to your grandma, the Western Union intermediary, which controls the funds between point A and point B, doesn't just abscond with the funds. That's why the rules are there, because they control, because money transmission involves control. And people have pushed. Remember they had this insane argument about it that like even a frying pan that transmits heat would be considered like having control over the heat. And
yeah, they were addressing the common sense argument that in order to transmit something, you need to have it. And they said a frying pan transmits heat and a USB cable transmits data, even though neither controls that thing.
Yeah. So it's been, luckily there is a statutory effort right here, the Blockchain Regulatory Certainty Act that Rep. Tom Emmer introduced in the House. That was included in the Clarity Act, which passed with a veto-proof majority, the Clarity Act. And it is in the Senate draft, the Senate banking draft of the Responsible Financial Innovation Act, which is their version. That does directly address this specific question, right, Zach?
Yeah, it both addresses this. And look, I don't want to let the government off too easy for claiming even that the guidance is unclear, right? Even if we're talking about privacy tools, there is a section of FinCEN's most recent guidance from 2019 about privacy tools. And they separate out privacy tools into two categories. They talk about anonymizing services providers and anonymizing software providers. And they say that if you're an anonymizing software provider, if you're providing software that allows people to spend money anonymously, you are not a money transmitter. If you're an anonymizing service provider, then you are a money transmitter. What's the difference? Twice in the sort of subsection about anonymizing service providers, they say that I'm reading a direct quote here, the added feature of concealing the source of a transaction does not change the person's status under the BSA. It has nothing to do with the privacy piece of it. The question is, are you accepting and then transmitting funds on behalf of the public? If so, you're a money transmitter. So this really is about control. It's not that there is explicitly, FinCEN says there's no special rule for privacy tools. So it seems pretty clear under the guidance that that's what this meant. And I think the President's Working Group memo, the 168-page crypto report that we talked about on the last episode, they talk about the Clarity Act and the BRCA codifying FinCEN's guidance. And so I think there is now, pretty broad recognition that is in fact what that meant. We had discovery in the Samourai wallet case where we knew that SDNY heard from FinCEN that that's what they meant. And in both the Samourai wallet and the Tornado Cash cases, the government dropped the part of the money transmission conspiracy that directly alleged that the defendants needed a license under the Bank Secrecy Act. And so it is terribly unfair and precedentially dangerous that the Samourai wallet guys pled guilty to money transmission, that Roman Storm was found guilty of money transmission, and the Clarity Act, or whatever the Senate version of that ends up being, is a full fix to this problem. It just says, listen, if there is any doubt under the statute, if you don't have unilateral independent custody or control, you're not a money transmitter. In the vast majority of circumstances that we could see someone building a tool like that.
And you mentioned Samurai. This, what we've seen now, it makes sense if they thought the winds were blowing this direction, why they ended up doing a plea deal, right? I mean, this sort of proves their rationale. Is that true?
Yeah, the Samourai guys drew a really bad card in terms of the judge they ended up with. They had a very tough judge to begin with, Judge Berman, who was kind of on the older side and seemed to maybe not clearly grasp all of the technical parts of the case. And then he was swapped out for Judge Coate, who was sort of notorious in the Southern District of New York of being one of the most pro-prosecutor judges, and someone who really throws the book at criminal defendants and gives really long, really harsh sentences, and who the first thing she did after inheriting this case was to basically summarily deny all of the motions from the defense, including the legal motion to dismiss, without hearing argument from the parties. And so they were looking at 20 years in prison if they were convicted of the money laundering charge. And so aside from any of the technical legal points, I think this was a very human decision of, Keone's 36, Bill's in his 60s. Neither of them felt like they could afford to risk 2 decades in prison.
Feels like maybe the wrong time to ask this, but it's fresh. Is there anything good at all that's come out of either of these cases? Is there anything that I know we're talking about silver linings, and so if the answer is no, the answer is no. But there's two of the three charges. The jury is kind of hung jury. Is that something we should be thrilled about? Is it something that's like, yeah, that was never going to happen? What do you guys think?
I mean, I think that is good, right? It was sanctions evasion and money laundering itself. And obviously there were people on that jury, at least one person, who refused to say that he did that. And, whether or not North Korea or other criminals, put funds through Tornado Cash, surely Roman didn't conspire with them to do that. Right? He didn't meet in a room or discuss or plan and plot. And, so there is some recognition, I feel like, from the jury that he also himself did not evade sanctions. Maybe his non-custodial app allowed others to do so. And so I think that's positive. And I think it, again, like I said, I didn't follow these pretrial motions very closely, but I think it's clear that the question on charge 2 is very narrow from a facts perspective for the jury. And, if that's it, that's how the cookie crumbled. I would say Judge Fela also did the Coinbase, SEC versus Coinbase case in SDNY, which eventually, right, both parties have resolved. So probably much more knowledgeable just from that experience, like at least has a very strong, huge crypto case already behind her with lots of other stuff. So probably wasn't approaching some of the basic concepts, for the first time. So maybe that was, had an effect. I guess it didn't keep Roman from getting charged. She did say, actually, by the way, too, another thing that I saw was in the sentencing discussion about, not the sentencing discussion, the bail, whether he could be stay out on bail while he waits for the sentencing hearing. She did say that he can. He's got a $2 million bond. They said he's got family. He's got, but she also said he has plenty of interest and I think plenty of intent to appeal. And so kind of acknowledging that an appeal's definitely coming here. And like, why would you flee if like you're about to appeal? And so I don't know, maybe Zach, you have a take on, like, I kind of read the comments that she said about that as acknowledging that like there were some things here that are definitely appealable. And I don't know if they usually do that.
Yeah. Oh, they're definitely going to appeal. Now, I do think it is surprising that Judge Fela came out what I think the wrong way on the legal argument, the motion dismissed, given that she came to the opposite conclusion in the Coinbase case on a very similar question about whether Coinbase's non-custodial wallet was liable essentially as a securities broker for allowing people to access DeFi protocols. And she carefully distinguished between custodial and non-custodial tools there and said, this is just software, right? This is not a brokerage. And I would think that same logic should apply to the Tornado Cash smart contract. She also said to the parties when we heard there was a verdict and before we knew what it was, that this is a hard fought case no matter what happens. And I think both there will be an appeal, and I think in that case that will probably factor somewhat into sentencing, where, okay, how much can you hold Roman responsible? Well, look, clearly there is at least some ambiguity as to whether what he was doing was a crime or not. I think the real silver lining of the hung jury on the money laundering charge, so the sort of centerpiece of the government's evidence in this case as to why Roman was guilty of the money laundering conspiracy, which requires intent and not just knowledge. For those who are not familiar with this concept, there's some crimes that require you to specifically intend something to happen. So if you're an Uber driver and the guy in the back of your car tells you once you picked him up, he's going to rob a bank, you're not guilty for aiding and abetting his robbing a bank. However, if you're the getaway driver and your intent is to help the person evade law enforcement, or you drive someone to the robbing the bank to help them rob the bank, and that's your intent, then you are guilty. And the money laundering charge would have required that intent. The centerpiece of the government's evidence here was a T-shirt that Roman wore to a crypto conference that had a picture of a washing machine. And the fact that that was not enough to convince a jury that he intended to launder funds, I think is helpful in deterring prosecutors from making these reaching arguments. The same thing would have happened if there was a trial in the Samourai wallet case. The centerpiece of the government's argument that they referenced at the defendant's guilty plea was this unfortunate tweet that one of them did about welcome to our new Russian oligarch users. And so at least this is sort of one data point on, you're not going to convince a jury that like a sort of off-color or misguided joke is sufficient evidence to convict someone of a specific intent crime beyond a reasonable doubt.
Yeah, good. Well, kind of one last question here. We can continue talking about this all hour, and that would be fine by me. But sentencing, retrial, appeals, what are the likely timelines for these type of things? What should we keep an eye out for?
So in the Samourai wallet case, they do not have the right to appeal. They're not going to appeal. And so, sentencing is going to be at the end of the first week in November. I think it's November 6th and 7th for each of the two defendants. My guess is they are going to get towards the statutory maximum here, the 5-year sentence. Judge Coate is a harsh sentencer. There was a really sort of weird and awkward moment in the guilty plea for Keone where Judge Coate was reading out the elements of the money laundering charge that they were not pleading guilty to and had to be corrected by Keone's defense counsel. And then she said, oh, well, it's much the same thing, which it's not. So I don't think that they're going to catch a break beyond what they arranged with the government in terms of their guilty plea. I think the Storm sentencing will, we're going to have to see how they handle the appeal, whether they're going to be able to run the appeals process before sentencing. But my guess is he is likely not to get the very maximum that he is eligible for from Judge Fela, who I think understands the mitigating circumstances here, understands that there is a lack of clarity in the law, and I think might be more disposed to be sort of reasonable.
Makes sense. All right. Alex, anything else before we keep moving?
It's that never-ending tension here between privacy and liberty. That the internet is like oxygen, right? Like it's a part of our daily lives, and I guess the best we can hope for is that this fight goes on forever, because at least it means that we're still fighting, because I don't see governments ever truly giving way on this topic. I would love to be wrong about that. Hester Peirce had a great speech on Monday. Maybe we should talk about this for a second, actually, directly related, and maybe for all we know, maybe even inspired by this tension, even perhaps with Roman's case. The SEC commissioner gave a eloquent defense of the idea that perhaps the Bank Secrecy Act does need to be rethought, that we should be asking ourselves as citizens about the nature of privacy and liberty and where the line should be. That's by far the most high-ranking U.S. official I've ever seen use language like that, and it was incredibly something about watermelons and peanut butter was her title. So if you Google that, you'll find her great speech, one of her many great speeches. But that's just my sort of takeaway here is there is a push and pull between liberty and privacy, and and then surveillance and control by governments, and that is not stopping. Even despite these, this unfortunate outcome for Roman and the precedent it may set and the state of it in the US, still have it a lot better than a lot of the rest of the world. If you look at the UK with the Online Safety Act, they just passed ridiculous legislation, something that's been trying to be passed in every country for years, and ours as well. Forget what they used to call it here. They had a whole push on it. Again, it's always under the guise of protecting children that we want to censor the internet, right? Like, and getting access to your messages. There's a European bill that I saw that is something called like the chat safety bill or something. It's literally that it's the classic thing they always want. They want to de-anonymize and unencrypt everybody's messages and be able to read them at any time. Like, so, and I mean, Australia has it bad. Obviously, more authoritarian governments like, in China and Russia certainly don't have privacy from their government. So there's maybe another silver lining. It's not just privacy advocates on the outside. You do have government officials like Esther Peirce speaking very eloquently about it as well.
That's a good point. Witness the cognitive dissonance of the U.S. government with regards to these, issues, and the, say one thing, do another, depending on agency and who's in charge. At least there is some dissonance within the government, and it's sort of, I mean, it's infuriating because it's happening, but it's not really come through the pipes. Will it ever make its way through? We don't really know to what extent, but yeah, I think that's a solid point there, Alex. All right, we've got a couple of executive orders that came out the last week. One of them I'll kind of take on. I had a really interesting conversation today, but first, I'm going to throw it over to you guys on the debanking executive order. What is it? Why is it important? And do you like it, love it, hate it? What should people be excited about? And are there any sort of misunderstandings or anything we need to get out of the way and clear the air on as we're examining the impacts of it?
Well, it's obvious that the president and his family themselves experienced debanking, right? Outside of their involvement in crypto, which of course now is significant. But so I think this was one of the earliest sort of things that they probably resonated, the Trump organization and family with the Bitcoin community on, was choke point 2.0, as people in Bitcoin and crypto refer to it as. And so not surprising to see it, the order. I would say we have already seen important things out of the banking regulators themselves, like removing reputational harm to the regulator, and as a reason why, as an examination principle for bank examinations, it does make a lot of sense. It is tricky. You can't this was led by the regulators. You hear this time and time again from the banks themselves, right? It wasn't like banks should have the ability to determine whether they want to bank with you. We're not trying to socialize and nationalize formally. I mean, banks are pseudo government entities in some ways, but like, right, like a bank is a business. A businesses have the right to decide who they do business with. But it's an attempt, I think, to remove political pressure from the government and its regulatory bodies on banks for political purposes. Keep in mind, the president and his family were huge clients of Signature Bank, the bank in New York that also had Signet and that also mysteriously was sort of executed overnight while other banks were saved. And then its crypto business was shuttered, but the rest of it was sold to basically to Steve Mnuchin. So like that bank, that one of the two main crypto banks that were sort of forced under during Operation Choke Point 2.0, had done a lot of business with the Trump family, was possibly seen by his opponents as his bank. So it doesn't surprise me. He talked about this in Nashville, and it's been a priority. I don't know, I haven't analyzed the EO itself too much yet. It just came out last week basically. But it's an attempt. It's an attempt, and it's more follow through, and it was a problem. It's been a problem here. It's been a problem again in other countries. And it's not fair to pressure banks to, and then, just for whole classes. I mean, it was one thing, I guess you could say it was one thing, the formal Operation Choke Point, which it was actually called under the Obama administration. They went after guns and payday lenders and gray area industries. But to lump, Silvergate's such a good example. Like they didn't even go bankrupt. They just wound down. Like Nobody even lost money there. Same thing at Signet. They, Barney Frank said they were solvent. Why weren't they given access to the BTFP? And why was Silvergate's line of credit from the farm bank closed? Like, didn't make sense. There's clearly there was something afoot. And, we think we know what it was, which was wholesale attack on the crypto industry by the White House, led by the White House, led by the NEC, led by people at the Fed, led by Mike Hsu, the former acting comptroller of the currency at the OCC, right? There was a sustained effort. And I think these EOs in general, like they set policy for the executive branch, but that is good in and of itself. It does something. It pushes further. It tells the government agencies that work for the president that I won't stand for this. They can obviously be undone with the stroke of a pen under another president. It'd be great to see some kind of legislation on this to codify in statute.
I think this issue has become a little bit of a political football, which I think is unfortunate because, if the right goes too strong down this path, the left is going to reflexively now decide they love debanking. But I think it is important to keep shining light on what happened here. It is really disappointing sometimes to see like the New York Times will talk about Operation 2.0 as a conspiracy theory. And it just wasn't. It was a real thing. I had a very front row seat to it. I run a law firm. I work with a bunch of Bitcoin and crypto startups. And it was for a while impossible to get bank accounts at any of the sort of big banks. Personally, I experienced this. I had to open up a attorney escrow account for my firm, for a vanilla law firm. We weren't launching a token. We weren't doing anything weird, but I did have the word Bitcoin on my website. And it took 9 months and trying to get, call in favors to intervene to get Citibank to open anything for me. Thank God for Mercury Bank was the solution during this period of time. They would let anyone have an account in 30 minutes. And so that was the saving grace. But this just 100% was a real issue. It was obviously correlated with Bitcoin and crypto companies. And I don't think it should be the policy of the US government to prejudge what sectors, what areas of technology are disfavored, and then without any democratic buy-in, try and kneecap those sectors due to political bordering on aesthetic preferences.
Yeah. So I kind of just did a brief, review of Cato did a write-up on this, and it's like regulators must remove the use of reputational risk. Banks must rebank people who've been debanked. Regulators must investigate policies. Regulators must investigate, religious discrimination. Regulators were the problem, right? It wasn't really the banks that were like, you know what, we're just going to debank a bunch of people. And so, I think that's kind of this is good. We're, like you said, we're shining a light on something that was an issue in the right kind of light. But, I think there's some current concern it may not quite go far enough. There's something in there about recommending that Treasury take a look at this. And so maybe it turns into more. But yeah, small win, maybe for now, potentially more down the road.
This is all still under investigation to some extent, both by the agencies and by Congress. But based on the reporting, it seems like at the core of this was a sort of informal FDIC quota for banking crypto companies, where they're like, listen, if you get beyond whatever percent, we are going to deem you to be high risk. And bank executives just didn't want to take that risk, and so they set these policies, which is what kept all these sort of Bitcoin and crypto startups out of bank accounts.
Yeah, well, hey, speaking of risk, right? Let's look at the next executive order. 401ks, I don't have essentially modernization, really interesting. And a lot of people are super bullish about it. Everybody's posting about it. I think it's been kind of a meme for a while. Like, hey, there's trillions of dollars of untapped capital trapped in these horrible 401k plans. And so I want to get your guys' input. I actually had an opportunity to speak with someone recently who has their ear to the ground on retirement plans and employee benefits, and had a really, really great conversation. They're not really in the Bitcoin space, but they're in that space. And I just asked, we're all excited about this, or we think it's really cool, and the industry is excited. What do we need to know? What are what are we maybe missing? How does this end up working too? Like, so an executive order comes out, hey, you can do this now. What are plan administrators thinking? What are employers thinking? And I know, Alex, you have some unique insight on this as well, but just to kind of TLDR for everyone. Some of you guys are preaching to the choir here, but I thought it was really interesting what they had to say and shared was, first of all, every new administration, just like everybody else, there's a new administration. This pendulum swings back and forth. This isn't anything to, I mean, this is great, but they have to kind of account for those swings of too many rules in Wild West when it comes to plan administration. And so this is a years long effort by private equity companies and teams to get this greenlit. So this executive order is essentially giving the green light to things that people have already been wanting to see for a while. And there's a lot of risk, right? So if I'm an employer and I have an employee that has $300,000 in a 401k account and they just nuke it down to 30 grand, one, they're pissed off. Two, they're suing me because how dare you put this product in my 401k as an option that I could invest in. And so that was kind of what I was wondering. Like, okay, so employees maybe want it. Employers are like, man, I can't do that because I'm going to get my eyes gouged out in lawsuits. How does this work its way through the system? And the answer I was given was a target date funds and age-based funds. And so, target date fund, I'm going to retire in, 2095 if I'm lucky, 20, whatever. And then the fund sort of sets that target date for you. They can automatically cap and like blend the allocations. And then the interesting thing, you can actually benchmark those against other target date funds and show, hey, this, risk adjusted return or risk profile actually outperforms when I include, sort of private equity, private credit, there's different types of real estate that you have access to now, Bitcoin and other cryptocurrencies. You put that all in a blend, your risk profile actually improves significantly. And so I thought that was really fascinating. Target date funds is sort of I would look there first to see, and that also, protects the employer. For context, 20 years ago, I verified this, there was like $80 billion in target date products. Fast forward today, 20 years later, we're over $4 trillion in target date products. And so it's a massive, massive market. I think all 401ks are like 10 trillion, give or take a few trillion, 10, 14 trillion, as somebody told me. And so that's a massive percentage of that are in these target date funds. So anyway, that's my alpha for the day. Alex, what do you think? I know you've kind of had experience there, and yeah, I'll let you guys shoot the fat on it.
Yeah, no, I mean, I agree with most of what you said here, Stephen. And like this sort of comes as it relates to crypto, and this is much broader to your point. It's commodities and real estate and private equity and alternative assets as an asset class generally. The president is ordering DOL to look at rescinding and allowing, doing rulemaking to do so, telling SEC and Treasury to figure it out, and et cetera, right? Like to allow alternative assets. And that includes specifically actively managed vehicles investing in digital assets is what was referenced here. So you're thinking about, that could be crypto funds, but it's probably talking mostly about ETFs and sort of like fund vehicles that own Bitcoin. These rules and in general for 401ks, to your point about target date funds, the reason they're so large is because many employees around the country of any type of job have a 401k plan. This is sort of like the primary way that working Americans gain retirement funds over the cycle of their careers outside of Social Security. And most employees in the country are not financial advisors. I mean, this could be any type of employee, right? And so it's supposed to be very easy, not too risky, generally, not too volatile. The target date funds are well designed in what they call the roll down methodology to adjust to less risky as you become closer to retirement, right? And the whole thing was like, imagine if you have to retire like on March 11th, 2020, when the entire market nukes, and now you got to sell your stocks because you still have a bunch of volatile stocks right at the bottom of the market, because now you are on a fixed income, right? Like now you are selling your investments, so it's to protect for things like that. Same thing. Like I had if you imagine you're going to college and you've got a 529 plan that you save for college, and then you have to start paying, got to pay out a quarter of it every year starting in 2008. Like that would be shitty, right? And so like these types of roll downs and like asset allocation strategies are meant to protect you from that and also kind of make it easy. And the DOL is very parochial, the Department of Labor, about how it oversees plan administrators and plan sponsors, right? So you are an employee, your company is the employer sponsor, and the plan itself is its own entity with its own fiduciaries, often employees at the company, but who have their own fiduciary responsibilities over things like asset selection and menu and what's available, and also can set thresholds. In 22, DOL put out a very, very strict guidance saying if any plan were to add crypto, Bitcoin or crypto, to their plan menu, again, not, I mean, not force people to have it, but have it be an option, that would result in significant scrutiny from DOL, basically, is what they said. And they had a giant list of things, and it was all the classic things like, how does the plan think about the volatility of the asset? How does the plan think about the portfolio strategy? What about the technical risk, and blah, blah, blah. Fidelity went ahead and did it anyway in 22, and they had created something called a digital asset account that plan sponsors could add to their 401k plan. And Fidelity is the largest administrator of 401k plans in the United States, something like half of the assets. And I don't think a lot of people did it because the DOL guidance was so scary that, like, the lawyers that advise plans and the accountants that advise plans and the financial advisors that plans hire to do their financial advising and tell them every quarter, every biannually, how the plans investments are doing, right? None of them felt comfortable doing anything with that. And so
Right.
that
Well,
was
one second.
rescinded.
So
Yeah.
just to clarify, Fidelity can make it available to add to the menu, but an
Right.
employer doesn't necessarily have to add it to the menu for their
Correct.
employees. Just to
The
clarify what
plan,
you're saying.
that's right. The
Right.
plan, which isn't the employer can sponsor the plan, but the plan itself is its own entity with its own committee of fiduciaries whose job it is to oversee that plan. And so Fidelity was saying the plans are the clients of Fidelity, right? Which Fidelity administers the plans on behalf of the plan. The plan sponsor is the employer that's sponsoring its employees to be in a plan, and the plans themselves weren't able to really get across the line on it, even though Fidelity is saying, look, we'll give this to you. And Fidelity had arguments and said that they thought it was, good, like, okay to do, not overly risky, right? And by the way, like, you can control for volatility with position size. So it was like, no one was suggesting, and I don't think here either, plans, even if they get comfortable from, so that DOL guidance that was really scary from 2022 was rescinded in May. So they're no longer saying that scary thing about crypto and plans. Now you have this as well, talking about other asset classes as well. Surely most plans, for fiduciary reasons, are not going to allow their employees, the plan participants, excuse me, is the language, to put like 100% of their assets into something highly risky. So what most plans will do when they start allowing these alternative assets is they'll set thresholds, right? They'll say like, oh, they can't put more than 10% of their plan or whatever. But the final thing I'll say here that's actually quite hilarious, almost many plans allow what's called a brokerage window in the plan. So like you can create even though the plan has this list of like, stocks, bonds, funds, like usually funds. So like ETFs or mutual funds of stocks and bonds, target date funds. The problem with target date funds is they're expensive. Target date funds have high fees. I mean, not like crazy high, but like they're pretty high, like 30 bips versus like, in the, passive index funds are like 10 bips, usually 10, 11 bips. Right. And so they're a little pricey, but what you can also have with that menu that's approved, most leave this option on called the brokerage window. And that allows a plan participant to go into their 401k plan, open up a normal brokerage account that can basically do almost anything usually, although the plan can put restrictions on it, but I don't think most do. And then you can just like buy IBIT or FBTC or BTCO, and many did. And something like 60% of all IBIT and FBTC, the two largest Bitcoin ETFs, are held at either registered investment advisors or broker dealers. And I would wager that about half of that value is in retirement accounts, either 401ks or IRAs. So people are already doing it, and they were doing it before the DOL rescinded that because you could just do the ETF in a brokerage window. So, I think this is interesting. In general, I'm in favor of people having the ability to have more investment opportunities. I think, you still have plan fiduciaries who are responsible for managing those plans safely. So like it's probably, and when you're a fiduciary, like you're personally liable, right? So like, you know, if I'm a fiduciary of a plan, I'm not gonna, we have to act in the best interest of the plan participants. So I don't think you're going to see like a giant spigot open with like a bunch of crazy assets and a bunch of plans. But I think it's good to see, more investment opportunities and investment selection.
Yeah, and there's a lot of PE firms and companies that have a ton of illiquid assets that now they have multi-trillion-dollar pool of liquidity to play in. So yeah, a really, really interesting executive order, and I think fairly optimistic about it. I'm excited about it actually. Zach, anything to add on
Yeah.
401ks?
I mean, it may not be a big spigot anytime soon, but it might be a small spigot tapping into a really big reservoir, right, of retirement savings. And I think the sort of main effect, as with a lot of stuff that the Trump administration is doing around Bitcoin and crypto, is it's either shifting the Overton window or signaling a shift in the Overton window that one day may lead to very significant flows. And this is an area where I think I feel very differently about it when I think about Bitcoin and crypto. I think Bitcoin is a very powerful long-term savings tool that I would like people to have access to. I would like them to not be afraid of. And I think it will do well by especially younger people that need to save up for the rest of their careers if we don't reach AI doom in the next half decade. But then when I think about like the rest of the digital asset space, I am a little bit worried about sort of the like ricochet effect of what happens if we get like a big RWA bubble where like, okay, tokenized stocks might be cool, but all of the like shitcoins people are going to create to, move these things around that don't have fundamental value. It just seems like each crypto cycle, there is a different, larger, more sophisticated pool of money that kind of gets scammed. And I think if it works out that there is everyone's sort of 401ks and pension funds getting rugged in a like traditional crypto cycle, I worry about what the response to that will be from a policy perspective.
Yeah, I mean, that would be terrible. I think we agree with that, right? I mean, but again, to me, the fact that you have fiduciaries in charge of these plans, like the plans get sued all the time for allowing someone to do a bad investment in their plan, right? Or like it going and worse, by the way, also for doing worse or allowing worse. But I think that's a bit of a guardrail on that. But I agree, like you don't want a meme coin bubble popping and causing people's retirement to go down at all.
But what you're saying about shifting, the Overton, going from it's too risky to include, and then sort of, looking at, I don't know, the traditional stock bond, capital market assumptions, like moving forward, being far not quite as strong as they have been, in the past, and participants saying, I it is a little risky. There's some risk here, but there's also risk in not having access to it in the plans. I think that's a powerful statement. And I think that's what we're seeing, right? Those who are stuck in 401ks, versus those who are not. Uh, I mean, to me, it's saying we recognize a certain set of assets that we have trillions of dollars that don't have access to, and they probably should have some degree of exposure.
What's the risk of offering a bond fund to a 20-year-old in their 401k? Like, I understand there are people who might need bond funds because of, they're going to buy a house, they're sending their kids to college, they're retiring. Exactly. I get it. But like without proper education, people can get wrecked in all sorts of ways other than the Bitcoin price going up and down.
Yeah, and of all assets, Bitcoin is a great long-term asset. That's the core thesis of the asset, right? That its scarcity and its decentralized nature is so, and it's actually the other point is that I want to make too is that by only being in stocks and bonds primarily, like this is it's basically a subsidy for the traditional equity and fixed income market, right? Like, because these are passive flows. Every single paycheck, many employees just keep buying them forever, right? And you have to, presume, and not just obviously crypto, but these other asset classes, like presumably, like they would like that. They would like people to be able to say, I want a recurring DCA purchase of my real estate trust or I'm looking at these, or my private market equity or whatever it is, right? Like it's contributed significantly to the rise of ETFs and passive investing, like the in retirement investing has.
Yeah, we're seeing this move already too. I mean, I know it's going to be it's not like all $4 trillion are going into these assets, but Apollo's making moves, BlackRock and Blackstone partnership. They're already, tectonic plates have been shifting for a while. We can keep talking about this. We got 10 minutes ish left. We're going to our lightning round, which is a thing I just invented, I think, for the Bitcoin Policy Hour. The Bitcoin Policy Hour lightning round of topics. We have a few to hit. We're already talking about TradFi and Bitcoin adoption. So let's just keep moving. And then we got to talk about Alex Thorn dumped 80,000 Bitcoin. Alex, what are you doing with the money? Congrats, or I'm sorry for your loss. And then SEC, we got to hit the SEC Project Crypto. So, Alex, let's talk about TradFi and then tell us about this OTC order.
Yeah, so like I would say from a TradFi perspective, like the core metrics you can look at are like ETF flows. I mean, and that's the product of choice for a lot of traditional finance, investment advisors, broker dealer clients, things like that. Bitcoin's got 54 billion since launch, and that's up, and that's the top. It's basically all-time highs in net flows. You've got ETH, which I mean, almost surpassed, but didn't Bitcoin a couple weeks ago in a week, but it has turned on a little bit. You've got people quite excited. The Treasury companies are doing a lot of the work here. There are 50 something Bitcoin Treasury companies that we know of, maybe more, that are literally doing the Treasury strategy, not people on BitcoinTreasuries.net that own Bitcoin, not entities, but that's a big part of the market right now. That is a big part of the story. There's a large wall of money from those companies that is purchasing. It isn't just MicroStrategy, although Michael Saylor continues to buy a lot of Bitcoin. I think, like, look, there are still people who are saying, because the government has changed its mind, I kind of like it now. You are seeing that still. I think there's a lot of macro stuff. I mean, Bitcoin has performed really well this year. It recovered faster than most to a new all-time high after the sort of like tariff shakeout in April. Ether still hasn't. It's just quite almost recovered its post-election high of 4,100 as of today. But I think, look, attitudes are positive. The regulatory stuff is moving, right? There's a lot of regulatory stuff happening. Project Crypto is one of those things. So I think people in general are bullish. You're seeing a lot of interest.
So another thing, that, and I think we probably hit on this before a different week, but the in-kind redemption on the ETFs, it's like, oh, in-kind redemption, but only sort of for some people. When is that going to, when is like Normie Street going to be able to do in-kind redemption? Is that coming? Is that a long way off?
I think it's a long way off, but it is a great idea. I love it. I think what you'll see is someone like a big brokerage firm like Fidelity will cut a deal with the authorized participants and or the ETFs themselves to sort of package up a bunch of in-kind create or redeem requests into sort of one basket and sort of like aggregate out. Like it's not really that retail can't. It's that it's the APs themselves that do the creates and redeems that can. But like you can, if you are big enough and to go to an AP and have them take your call, you could deliver them Bitcoin in kind and have them create like a Bitcoin ETF share out of it. And so it's more.
Is that true today that you could do that?
I think so, yeah.
Huh.
And that's going to do some interesting things. It's going to compress fees. It is cheaper for a lot of people that have a lot of Bitcoin not to sell it. It's also got big tax consequences, we believe, and I'm not an expert in this niche part of tax law, but we looked into this last week. Pretty sure if you create security ETF shares and with the in-kind securities, that cost basis carries. So you could imagine, let's say you're a big dealer in Bitcoin or you're a whale and you have access to the sort of crypto native APs, right? Like the Virtus and the Flowdesks and the Cumberlands, right? I mean, I don't think you're going to see JPM be doing, they're an AP on a couple of these, and like see them doing in-kind create redeems soon. Maybe you will, but there are some that are absolutely set up to do it. And they are going to have, a big party that wants to maintain cost basis is going to have, could have a benefit. You could decide, you know what, I want to do some options trading, but for one reason or some lending, but for one reason or another, rather than using sort of like more crypto native options like a Deribit or something for the options or a lending desk, you perhaps want to trade the options on the ETF shares or use margin accounts at prime brokerages for the lending, and you might be able to move in between them. The other point I would make is a lot of people think this is just like obvious. It's really not that complicated. It should have been allowed. It probably wasn't allowed because it disadvantages the banks specifically, right? The banks at the time, in particular, in 2024, were not able to touch crypto. Banks, broker dealers, all these types of entities, they hadn't, where the SEC hadn't done the work or had intentionally not done the work to allow broker dealers to do rulemaking around how broker dealers are supposed to touch Bitcoin and Ether, and they still can't today, right? So I think this was sort of maybe a compromise that the SEC said, look, we know how to do cash create. It is possible. It is less efficient, but let's just go ahead and allow it that way at the time. And so now banking rules have changed and regulations are changing. You've gotten stuff from national banking regulators. You're getting things from even the Fed is starting to, make a few changes on what banks can do as it relates to blockchains. And so maybe they won't be disadvantaged anymore, but it honestly, this is a bit for now, for sure. It is sort of market plumbing. It's not really like you and I can do it. Most likely not.
Yeah. That makes sense. That makes sense. And I don't know if you guys caught it, but I might have coined a new phrase a couple minutes ago. I did Normie Street. I've never heard anyone say it before. So trademarked
as
that
opposed
is
to Wall Street.
Yeah. You got
Yeah,
Wall Street, you got Normie Street. That just came out. So we're inventing things on the pod. Sell order.
Yeah.
Give us the TLDR. What happened? And, was it Satoshi? What happened?
I can't really say anything about the identity of the client. I would say that, what we said was that the client sold for estate planning purposes. I will say, like, one of the interesting things about this to me is like, there's kind of a myth of lost coins. Like, I mean, these are coins that I can promise you, like Glassnode and these other like data providers counted as lost. Just assume they were lost, right? I mean, they haven't moved in 14 years or something. And I think it's actually a really powerful story about Bitcoin. You really can like have keys hidden away for 15 years and then come back and have it be your life savings or whatever it was, right? Like it does work. It really works. And I don't know, look, I mean, we work hard to protect the privacy and also service. Like, I mean, this is a big order, right? Like of our clients. And so, we're happy to help. I mean, I'd personally prefer to see someone come in with, 9 billion in cash, say they want to buy Bitcoin, but look, it's a free market in a free country and Bitcoin it works. It actually works. And I don't know if people saw this, but we actually put that press release that we put out on chain, having a little bit of fun with some wizardry. I did this and a non-standard oversized return transaction that had the press release in the op return, an oversized op return. So, having a little bit of fun with the Bitcoin nativeness. I think, if you're somebody with a lot of Bitcoin, right? Like you don't want to be that public. You're worried about wrench attacks and other things. And I think it's reasonable if, it's the biggest notional sale in the history of Bitcoin, as far as we could tell, dollar value sale. It's not technically possible to know because like you'd just be selling all the time in smaller chunks or something, but we'd never seen anything that we're aware of that was this big. And, client wants privacy. So, make it clear that they're out.
Well, it's fascinating. I think you're right. It's an incredible proof of concept. It's fascinating to see, like you said, coins that everyone thought were lost. Everybody talks about the percentage of Bitcoin that's perceived to be gone forever, lost forever. We really have no idea. Bitcoin destroys all your models, and including the coins that you're assuming are lost. And so,
and if you sold $9 billion of Bitcoin like a couple years ago, you'd have dropped the price like 45% or more.
So that's the other thing. That's just remarkable.
This is a way bigger market now.
It didn't even cause us. It was nothing. That's 80,000 Bitcoin are dumped. You hardly notice it. There's a little short term, but that I don't even know that had anything to do with the sale. Maybe that just had to do with the, kind of the fear. But Bitcoin works. Somebody has 80,000 Bitcoin. They sell it privately. No one knows who they are, and they go about their life. And I think it's whatever, buy, sell. I don't care. I think it's really cool, and it's beautiful. Honestly, it's really really neat. Zach, what were you gonna say?
It's great. I mean, it's interesting to think through how instances like this affect the conversation around what we're going to do with quantum, right? Because there's the hypothetical man in a coma, and then sometimes that man actually wakes up and sells $9 billion. And so, yeah, curious to see how this looks going forward.
Pull on it a little more, Zach.
Well, there's a question we've talked about on the show before about, if we need to upgrade to quantum proof cryptography, and that might be a hard fork, that might be a soft fork. What do you do with the most vulnerable coins that use old address formats, that are lost, that are whatever? What do we do with Satoshi's coins? And broadly speaking, you can either burn them in one way or another by invalidating them, by saying your coins are only valid if you move over to the new fork, by recycling them into block rewards, by what I think is the worst of all options of moving them to a multi-sig for a new Bitcoin Foundation high table, or you let them sit there and get hacked, including maybe by the Chinese Communist Party, and that has its own set of concerns. And one of the sort of central themes of this debate is the sort of Bitcoin property rights, and does it sort of violate what we think of as the sort of property rights inherent in Bitcoin by either confiscating coins prematurely or by insisting that you have to sign and move coins or else you are necessarily going to lose them, as opposed to they get hacked. And this gets into sort of interesting philosophical stuff, right? St. Thomas Aquinas and the doctrine of double effect. And if you let them get hacked, is that the same as setting a deadline, and what's intended versus not? But I think the fact that there are apparently people out there that have not moved coins in well over a decade, and that if we made people move over to a new fork, they would be forced to sign and maybe dox themselves. I think that just is an interesting input into that conversation.
Yes,
I totally agree. It's very interesting.
Totally agree. I knew all of that, but I know there's some people listening that didn't know all of that. So now you do. You're welcome. We only have a couple minutes left. It's like I have an echo in here sometimes when I'm talking to Shapiro. I'm just hearing my own thoughts. We've got a couple minutes. Zach, can you give us like a 30-second rundown of SEC Project Crypto? We're going to be back next week. Sorry.
Yeah, so we'll have to get to more
next week.
detail then. But the TLDR is the SEC has a lot of rulemaking authority. Aside from the rules that Congress passes, the SEC can issue no action letters, they can have interpretive guidance, and that just moves a lot quicker and is going to be more specific and more informed by experts than a market structure bill like Clarity. Right? The Clarity Act is really based on FIT 21, which is a compromise bill from the end of the Biden administration, where the sort of main effect is to create this safe harbor from the Howey test for people who are launching coins. But it's not a comprehensive solution to what do we do with the securities laws and crypto, whereas Project Crypto is really more about how can we facilitate things like actual securities on chain. How can we create a supportive regulatory environment for capital formation, other than just saying that we're going to make it harder for the next incarnation of Gary Gensler to come sue you.
Yeah, still great. Awesome. Guys, thank you. Alex Thorn, Galaxy, we love you, man. Thanks for hopping on the pod.
First ever non-BPI guest.
Yeah.
Really? No way. I'm honored, but I still have the BPI bag right there. So
you got the bag.
I'm repping it.
I got the swag. I know you got to go, man. Thank you for hanging out with us for an hour. Shapiro, as always. And thank you guys for letting me host today. It was fun. And I think we're going to be back next week. So we'll talk to you then. Peace out.